Hello, everyone, and welcome to Let's Talk Insurance with Janet Smart Agency. I'm your host today, Janet Smart with Farmers Insurance. I am here with a special guest today, Landon Reeves. Landon, welcome.
Thank you, Janet. Thank you for having me.
Can you tell me a little bit about your background as a lawyer?
Yes, absolutely. So I have been practicing law since 2016. I started out practicing corporate law, securities, and mergers and acquisitions for big companies. Did that in Little Rock for about 3 years, and then my wife and I decided to start a family. And when we started having children, we wanted to move back home, back to Batesville, and enjoy a slower pace of life. And at that point, 2018, when we moved back, I opened up my own practice at that point, and I have been off and running since then. And it has been just a wonderful practice, a wonderful 5 years, and look forward to many more.
Wonderful. I agree. Batesville is a wonderful place to be, and hopefully as our kids grow up, they all come back too, because again, it is a wonderful place. So many of our listeners may wonder why I'm speaking with a lawyer today in regards to insurance. Being an insurance agent, I do advise customers to protect their assets. And over the years, I've experienced families that have to sell assets, including homes, to pay for nursing home care, for instance. Many people plan for death, but not unexpected nursing home bills. And so I am calling on you, the expert. What do you recommend to keep this from happening?
Absolutely. That is a great question. And my practice primarily includes estate planning, and with that, probate, litigation affiliated with probate, any and all estate litigation, and also business and commercial litigation. And so estate planning and probate is a huge part of my practice, and I come across that question all the time. And so when talking about estate planning, there are certain boxes that we want to tick, certain goals we want to achieve in estate planning. And one of the first is to work to avoid the probate process. And for that, I mean work to allow a person's assets to flow down upon their passing, down from them to their spouse, children, heirs, or beneficiaries, whoever they want, without the need to file for probate, the expenses of probate, the time duration of probate, and the court intervention that probate includes. So avoiding probate is oftentimes one of the first goals to achieve in estate planning. The second goal that estate planning seeks to achieve would be to make sure that the assets of the individual go down to the heirs in the most tax advantageous way possible. Absolutely. so that folks don't get hammered with capital gains taxes by any sort of missteps in their estate planning. And the third is primarily, as you've alluded to here, is the cost of nursing homes. And with that, what I mean by cost of nursing homes, what I really mean there is Medicaid eligibility. And so Medicaid is the governmental program that typically pays nursing home costs on an individual's behalf if that person has what I would consider a nominal valued estate, or otherwise effectively they don't own anything. And so under Medicaid rules, if you own property and you have money and you have all these assets to be able to private pay, then you have to use all those assets and that money to private pay until you get down to having about $2,000 in a bank account, and you're allotted a certain amount of income, very low amount, and so an automobile worth about $2,000. So effectively, your bank account can't ever rise above $2,000, otherwise you would not be qualified for Medicaid. There is a homestead exemption for Medicaid, to where Medicaid will consider your home exempt, but if you've got property above and beyond your home, then that could preclude Medicaid eligibility as well. And so Medicaid planning is an important part of estate planning. And so with your question about what to do about nursing home care and these other issues with regards to estate planning. The answer is, in short, that we want the assets of a person to go down to the family or to the heirs in the easiest way possible. How to achieve that? That could be achieved either by a will or by a trust. And so, by doing a will tells the probate court who you want to have, who you want all your assets to go to upon your passing. A will does not avoid probate. A will still has to go through probate. So right off the bat, our first goal was to avoid probate.
Gotcha.
A will does not avoid probate. Okay, so that's a common misconception. Somewhere within the past 100 years, folks have been told many a times over that if you have a will, it avoids probate. That's not true. A will has to go through probate. A will simply tells the court who's to receive those assets. Whereas if you don't have a will and your estate goes through probate, then the court allocates those assets according to the default rules, laws of Arkansas, the rules of intestacy. So you got the default rules of intestacy where the court says it goes to these heirs and these fractional shares, whereas a will say, I want to bypass those default rules and I want my assets to go to these specific persons, okay?
Yeah.
And so it does not avoid probate. However, it does help for tax purposes. It gets a step up in tax basis for any inheritance received. And a will does nothing with regards to Medicaid planning.
Gotcha.
So a will is sort of the basic, easiest, quickest, cheapest route for estate planning, and it's better than nothing.
Okay.
But it's certainly not comprehensive. It's not comprehensive in that it does not avoid probate and it does nothing for Medicaid planning. Okay.
Okay.
And so then our next step is, okay, what does avoid probate? What does help for nursing home planning and Medicaid? And the answer there is trusts.
Perfect.
Okay.
Perfect.
And so a trust is a legal entity that is created, and a trust is a mechanism. It's a legal concept by which assets, money, property, various things that a person owns can be put into that trust for various purposes. And there are many, many different types of trusts. All trusts are not created equal. Far from it. These trusts can vary in size, complexity, mechanisms, and details. They can be as complex as you want or as simple as you want. And so now in talking about trust, there are two primary basic types of trust. There's what's called a revocable trust, which means that a revocable trust can be revoked by the person creating it. So say, Janet, you want to create a trust, you create a revocable living trust, right?
Okay.
We've heard that term at some point. And so what that means is that you are the trustee of that trust. You have the ability to amend that trust, to revoke that trust, to terminate that trust, to put property and assets into the trust, to take property and assets of the trust. You have all power and control over that trust, okay? So that's a revocable trust. A revocable trust avoids probate.
Okay.
It provides tax advantages for the heirs in that they receive the inheritance and property and assets through a trust, through inheritance, which is a good thing. But a revocable trust doesn't do anything with regards to nursing home planning, because in nursing home planning, Medicaid planning, the idea is to put your assets into a trust, not a revocable trust, but an irrevocable trust, an irrevocable asset protection trust. And for that, so now I'm talking about irrevocable trusts. If you wanted to create an irrevocable trust for Medicaid planning purposes, you could not be the trustee of that trust. Somebody else would have to be the trustee of that trust, a third party, a family member, not your spouse typically, and oftentimes a corporate trustee is necessary for Medicaid planning or ongoing Medicaid eligibility. And so irrevocable trust means that it cannot be revoked by you, and you can't amend it. Typically, you can't rescind it, and that you are turning over control of that trust and all of its assets to the trustee. And then the trustee is bound by certain terms of the trust, certain rules and laws, and one of which we would want to build in there is to either achieve or sustain and maintain Medicaid eligibility. And so for that means that for Medicaid planning, I said earlier that you can't really have any assets if you're going to get Medicaid eligible, right? Because if you have assets and money, then you have to private pay down to next to nothing. And so what you would do is put your assets into as much assets as you could, as many assets as makes sense, put those into an irrevocable asset protection trust. You would appoint a third party as that trustee.
Okay.
And they would administer the trust for you, but you do not have the ability to amend that trust, to revoke that trust, or to put other assets into that trust typically, or to take property and money out of that trust. That's the important part, because for Medicaid purposes, if you have the power and control to take money and property out of that trust for your own benefit, then you still control it. Even though you maybe don't own it, because now the trust owns it, you still have control over it.
Yeah.
And so for that means that Medicaid will look at that and say, those assets that she has the ability to reach into, and that money she has the ability to pull out of the trust, she still has power and control over those, so those still count towards Medicaid. So that wouldn't do anything for you. What you have to do is relinquish power and control over all those assets in that trust, have a good trustee that understands Medicaid eligibility and understands trust mechanics and understands how to administer a trust in a way that will preserve that Medicaid eligibility, such that those assets can be used for your benefit, right? It can help pay for your life, your bills and expenses and healthcare and all these various things that Medicaid will deem as exempt transactions, so that it can help, those assets can still help you throughout your lifetime. You just can't get into that trust and take out money and put it into your own name whenever you want. Okay?
Gotcha.
And so that's the name of the game with regards to estate planning. Nursing home planning, Medicaid planning, and asset protection trust can be very complex. There are various types of asset protection trusts. There are a special needs trust, whereby a parent or a family member may set up a trust for a special needs child or a special needs adult. And so that's helping to preserve their Medicaid eligibility and their disability, things of that nature. And so what that means is that a person is setting up a trust for the benefit of another person entirely. Whereas if you're talking about Medicaid eligibility for your own purposes, for nursing home, then for that would be an asset protection trust, sometimes referred to as a domestic asset protection trust. And for that, you're setting up your own trust, right? You're putting your own assets into your trust, and you're using those assets to help with your own ongoing needs throughout your lifetime.
Difficult times remind me to take stock of what's most important. That's why I'm here for you and your family to discuss your insurance options and help you select coverage. With over 14 years of experience as a farmer's agent, I take pride in being able to help you protect the things that matter most. Call me, Janet Smart, at 870-793-5757 to learn more.
Underwritten by Farmers Truck Fire Insurance Exchanges and Affiliates. Products not available in every state.
So those are the two primary types of trust, revocable and irrevocable. Irrevocable branches off into many different types of irrevocable trusts, but that's the direction you're heading when you're talking about Medicaid planning for the future. And keep in mind that with Medicaid planning, that you need to get your estate plan, you need to get your whatever type of trust you need, and the transfer of all your assets to that trust, you need to get that accomplished 5 years prior to going into the nursing home.
And who knows when that's going to be.
That's exactly right. That's exactly right. And so one thing I see a lot of is, somebody will call and say that, their mom or dad's going into a nursing home next week and need to get them Medicaid eligible. So for that, the 5-year window has lapsed, right? That's no longer part of it. That's called crisis planning. And that's a whole other ball of wax in and of itself. What I'm talking about here is if a person's in their 60s or 70s, something like that, then maybe it's time to start, talking about transferring all their assets to an irrevocable trust, appointing, a child or a corporate trustee to manage that trust for them, so that in the future they could become Medicaid eligible. But not something that's going to happen immediately. Because, again, in order for those assets to be exempt from Medicaid purview, they have to have been put into that irrevocable trust 5 years prior to the time of which you need to become Medicaid eligible. So it's looking into a glass ball of which there is no answer. You don't know when that'll happen or if that will happen.
Exactly.
And so for that, everybody's situation is different. Not everybody's nursing home possibility is created equal, in that not everyone, will go to a nursing home. Certainly some people have more support with family in a local area that can help them. And so it varies from person to person, and it varies from circumstance to circumstance there's no, and if there's any point of advice that I would hope folks would take away, there is no one size fits all for estate planning. And what you'll hear so oftentimes is, oh, well, I knew somebody who did this, or something that did something different, and so oftentimes it's done differently for somebody else because their circumstances, their assets, and their whole dynamics of their situation is just so different that you can't assume that what they did will also work for you. So it really, estate planning is so customized that it has to be curtailed and it has to be custom to a given person's circumstances, and for that you need an estate planning attorney that can navigate those waters for you.
And I'm sure what you set up in your 40s, 50s, 60s is different years later. So you need to have that follow up.
That's exactly right. So when I have folks come to me that are in their 30s, 40s, 50s, and 60s, it's very rare that I recommend to them that they be thinking about Medicaid eligibility.
Yeah.
Because to do that, oftentimes, or means relinquishing a certain amount of control, or it means creating an estate plan that is just honestly far too complex than what they're bargaining for and than what folks want. I mean, you could set up an estate plan with an irrevocable trust and then tie that to a revocable trust and then have multiple LLCs and partnership interests. And it becomes so cumbersome that it's almost more than it's worth in that regard. And so what I tell folks is, if you're in your 40s, 50s, 60s, I think the flexibility that a revocable trust, the simplicity that a revocable trust provides is the best route. And then when you get on up towards the age of which you're no longer, making big moves with regards to buying and selling a property and assets, and everything's pretty well settled and you are at a good point to relinquish control of those assets to someone you trust, then it makes sense to do so. Yeah. But before that, losing control of your assets is generally just not a good move.
I think that's amazing. That sounds perfect. I think a lot of people think kind of like life insurance, for instance. It's you buy it, you forget about it, and it's not like that. Things change, and so in the event that someone doesn't have a will or a trust, what happens to life insurance assets?
Great question. So if somebody doesn't have a will or a trust, all of their assets go through the laws of intestacy, which are the default laws of Arkansas, and it's a breakdown that says to the children, and then part to the spouse, part to the children, and then from there it just goes down this sort of family tree until it finds the nearest relative. Gotcha. To put it basically. But with regards to life insurance, number one, life insurance is an extremely important part of estate planning, because life insurance, what I tell folks, life insurance, if something happens to you, and if you have a mortgage on your property, if you have any sort of substantial debt, bare minimum, I tell folks that they need life insurance to help such that their spouse is their beneficiary for that life insurance policy. And so that if something happens to them, at least their spouse can use those life insurance proceeds to pay off any debts, so that they're not susceptible to any sort of foreclosure or, just a significant decrease in income or a significant increase in expenses. But so that bare minimum, your spouse can be taken care of in the relief of any debt that you had. So if somebody has, say, a mortgage of $100,000 and a vehicle note for $40,000, I would at bare minimum recommend a life insurance policy at $200,000 to $250,000, something like that, to start, such that if something happens to them, and this is true for young people, this is very true for young people, if something happens to you, at least those funds can be allocated to your spouse to pay off any debts, which can relieve any financial burdens that may result to them from your passing. And so life insurance can help the spouse in that regard. And then life insurance is also important if you own a business and if you have a business succession plan in place. Life insurance policies can be very helpful for business succession planning, particularly buy-sell agreements. Oftentimes, a buy-sell agreement will include life insurance policies on those partners, such that if something happens to one partner, the other partner can buy that other person's share from them. They can use the life insurance policy proceeds to do so. So effectively, it guarantees that a person's family would be able to buy, the shares of another in the event that somebody passes away. It provides the readily accessible funds to fund that transaction.
Yeah.
So life insurance proceeds are just equally as important as a will or a trust with regards to estate planning, because at the end of the day, you could have the best estate plan, but if your spouse passes away and you're saddled with a large amount of debt or a significant decrease in income or a significant increase in expenses, the best estate plan may not particularly help with regards to something like that, in which case your spouse would need help paying for those things and relieving of that debt. And that's where life insurance policies can come in as being very helpful tools with regards to estate planning.
Anything else that you'd like to share that people should consider in preparing and protecting their assets?
Well, to kind of tangent off of the life insurance question, in the event that somebody passes away with a life insurance, or say that somebody has a life insurance policy or bank accounts or investment accounts, retirement accounts, any sort of financial accounts, what we always want to do is double check their beneficiary designations, because that's so important in avoiding probate for those particular accounts and making sure that they go directly to the spouse or to the heirs, whoever you want them to go to, but in a way that avoids probate. And so what I mean by that is, if you've got a life insurance policy, make sure that your spouse or your children or whoever it is that you want to have those things, have those proceeds, that they are the beneficiary on those.
Okay.
And then if you have a trust, oftentimes it makes sense to make the trust the secondary beneficiary of those. Okay.
Absolutely.
And then same thing with bank accounts and investment accounts. Double check your beneficiary designations. Make sure that you've got those set the way you want. And if you've got a trust in place, typically make the trust your secondary beneficiary on those, such that if something happened to your spouse and your spouse is no longer with you, then those funds would be payable through your trust and would go down to the recipients of your trust, outlined by the terms of that trust.
That is fabulous information. So I am going to be going and checking on all of my documents here. I would like to thank you, Landon, for helping us learn and understand how trust, wills, and can protect your family. And so I would ask this: how can people reach you?
Absolutely. So my phone number here at the office is 870-376-4455. I'm located in Batesville and travel really all over North Arkansas. We do house calls for folks that can't get out. Folks are in a hospital or a nursing home. That's not a problem at all. We can go anywhere we need to go to help folks. And so give the office a call. Our website is www.batesvilleattorneys.com. And I am located in the large white house across from the Chamber of Commerce on Harrison Street in Batesville at 520 Harrison Street. So feel free to give me a call if you have any questions. I don't charge for consultations. I give away free advice all day, every day. And, charging for consultations isn't the way that I do business. So if anybody has a question, feel free to give me a call and I'll give you the best answer that I can.
That's fabulous. Thank you so much. And yes, it is a beautiful big white house across from the chamber.
Thank you.
And thank you for taking time to listen today. I hope you've learned something new about insurance and protecting your assets. If you have any insurance needs, please contact us at the Janet Smart Agency, 870-793-5757, or at our location at 3242 Harrison Street in Batesville. Janet Smart Agency, the smart choice for insurance.